Now, how important a company having a compliance program is in the beginning of that process, meaning when there is an investigation and the company is then facing a sanctions decision or a sanctions proceeding.
Yeah, it actually is very important. It is under the sanctioning guidelines, the World Bank Group sanctioning guidelines. You can see that there is mitigating credit that may be given if a company has an integrity compliance program in place. Now, the mitigation can be in the form of maybe a reduced period of sanction. It may factor in as well in terms of the type of sanction, so debarment with conditional release, conditional non-debarment, but it certainly is something that will be considered. Now, and that is why we do get involved. We as a standard practice now, some of the investigators will, on our behalf, request the respondents in the cases to submit integrity compliance program related materials. And then we will have an opportunity to review those materials and give a view as to, as I said, the baseline. What does this company's compliance posture look like at this point in time? We do not recommend what mitigation credit is warranted. So, for example, we don't say, well, you're looking at a 5-year debarment with conditional release. We think, 2 years should come off because of the program. We simply say this is our assessment of the program, and then it is left to the other teams to place any mitigating credit that may be warranted. So it really is an extremely important aspect of what is considered for in terms of what the sanction may look like, but it also is quite relevant for what the release conditions may be. Because we, especially in the settlement context, we will actually negotiate with the sanctioned entity with respect to the sanctions condition, the release conditions, the compliance conditions. And so certainly we will take into account what that baseline is when we are fashioning, a full integrity compliance program, a tailored condition. Do we think an expert or a monitor should be appointed in this particular case? So it really carries through the entire process.
We know you assisted many companies over the years in meeting several different compliance standards, particularly companies that deal with in the infrastructure sector or that participate in public procurement. So I know you know many different standards, but is there something particular about World Bank guidelines? Are there potential benefits for a company when it's adopting its compliance program or improving its compliance program? Are there any potential benefits for the company to consider the World Bank standards, and in what sectors and what types of companies would you say should particularly pay attention to World Bank guidelines?
So on the World Bank standards, I'd say that, and you can hear that from what Lisa was saying, the main aim is to deter cases of misconduct, at least on a systematic basis. Now, I'm not aware of any studies on the particular aspects of a World Bank compliance system. From what I think, from what I have observed, there are some peculiarities, though, because of the role of the World Bank in financing, projects in developing countries. So, in particular, when you look at compare that to large infrastructure programs or contracting authorities reviewing compliance mechanisms, I think there is a difference in the way you look at a program. So contracting authorities very often only look at the piece of the paper and say, okay, that looks fine, that's standard, let's move forward. Whereas the World Bank has a much more thorough look at that. So they will naturally look at the papers, but they will also look into how the program is implemented. So will they, is it really in the DNA, in the day-to-day culture of this company that their compliance program is actually lived. So I think that's a major difference. And that's a difference that plays a role in the World Bank investigation, because it is really pivotal to show that you have actually implemented the system. So you'll need to show, for example, training materials, audits, expenses, all of that. So it's a much more practical approach than you see in other examples. Now, with regard to the benefits, Thiago, I think a great example of how that is beneficial is what Lisa was saying, is that it is considered, first in the investigation phase, but also at the later point in time when Lisa reviews the compliance program. So it's beneficial naturally to have a working a compliance program in line with the World Bank standards, because it will be the only means to get off the World Bank hook. But I think above that, if you look, the World Bank, compliance standards are probably like a gold standard. So it will help you in having discussions with other international institutions, with other multilateral development banks. So I think it's really a very beneficial aspect to adapt the compliance program to the World Bank standards.
Are there any particular areas where the World Bank is more focused, or would you say that its standards are higher than you would expect? For instance, Lisa mentioned facilitation payments, right? Which the World Bank expects companies to have a blanket prohibition against facilitation payments, but we know that there are some legislations, particularly the FCPA, that, for example, allow companies to make facilitation payments. So in that sense, the World Bank is a bit stricter, has a bit higher standard than U.S. law. In your experience, is something particular to the World Bank that is, I think, more strict than you would expect, or more developed than you would expect, and does it change? And Lisa mentioned that, right? That the World Bank takes into consideration the size and location of the project, the particulars of any given company. But is there anything that it would point out as particularly strict, or something that is a particular area of risk for the World Bank?
Well, I think it's a good and a difficult question, because the risk analysis, which is the first step in a World Bank investigation, or in any other compliance investigation, will always it will depend from company to company. Perhaps there is something, some areas where the World Bank will really be more focused than others, and which also goes back to the financing of projects in a number of developing, perhaps more poorer countries. And I think one of these areas is probably subcontracting, agents, third parties. So whenever you have a company using someone else in the course of acquiring business, that's something that it will certainly be something the World Bank will be looking into. Bluntly, do you really need an agent? Does he work for the money you pay him, or is he just a means to bribe an official? So that's life is a bit more complicated than that, but that's the question that you will have to answer with regard to subcontractors, agents, and so forth. And perhaps one area which I think goes in line with what I was saying about the World Bank, you're really looking for you how to implement it in your day-to-day life. One area that you see very highlighted in the World Bank review is training. So it's really important that from top to toe, really from the very C-level to the employees down the chain, that everyone understands how the compliance system works, and you can only achieve that by training people. Having a robust, comprehensive training program running throughout the organization. I think that's really a key area where the World Bank is probably more looking into that than some of the other compliance organizations.
Changing a little bit from from a topic to region. We know you, BLOMSTEIN and you particularly work all over the world. Can you elaborate a little bit on what you're seeing in terms of risk areas for companies that are engaged in construction projects and infrastructure and public procurement in Brazil and Latin America as a whole? What are you seeing in terms of risk trends or prevention trends that you could highlight to our audience today?
Okay. Well, I think if you look at the risk trends from a World Bank perspective, then I think it's fair to, there are two aspects that I'd like to point out, that come from the role of the World Bank and from the way it treats compliance programs. So the first issue I'd like to mention is, the definition of potential irregularities. So the World Bank, and that's aligned with the other multilateral development banks, has a very broad definition of prohibited practices. So for instance, if you obstruct a World Bank investigation, that in itself can be considered as a prohibited practice. And another area where you can, very easily run into a prohibited practice is if you provide erroneous documents in a procurement procedure. And it doesn't really matter whether that erroneous document was decisive for you to win the project. It's not even necessary for the bidder to have won the competition. And it's at the same time, it's not relevant whether he won the competition and thereafter, completed the project in time and cost. So everything that matters is that you provide a wrong document, a false document. So even if it's about a minor area, you can be debarred for issuing this document. And the trick is that also works if the document wasn't produced by the company, but by a subcontractor or by an agent. So, you have a broad liability, and that's can be quite challenging in countries, in Latin American countries, where the concept of compliance isn't as omnipresent as it is in other regions of the world. So I think that this broad definition is really an area which can cause you quite some headache in Latin America. And the other area I'd like to mention is the burden of proof that the World Bank uses. Now that at first it may sound odd that it's a very technical aspect, but that technical aspect has quite an implication on the way in which you treat you analyze a risk. So unlike a criminal judge in a national state, the World Bank doesn't have the same means. So which means from a burden of proof for you to be sanctioned, it's sufficient that it's more likely that you did something wrong than if you didn't do it wrong. So this means really a proper documentation of the compliance aspects is a key to avoid a sanctioning by the World Bank, which means that you really have to be able to show that you did everything you can to avoid any compliance risks in a project. And that may be, the o jeitinho brasileiro, it's normally not very well documented. So sometimes you may run into a compliance risk because you basically failed to document that you did everything in order.
Now, Lisa, moving on and going back to the last section of our discussion, one thing that is particularly interesting and I think of concern of companies that act on those projects on the World Bank is the cross-department effect. I don't think that that's something that companies are particularly aware of. So it would be great if you could run us through what the cross-department mean and what are the standards? Are the standards the same for every multilateral bank? What is the reach and how can companies be affected by the cross-department provisions?
Yeah. No, thanks for that question, because I think the cross-debarment regime is actually extremely important. And there is a formal cross-debarment regime and a more informal cross-debarment regime. So formally, there is a cross-debarment agreement between several multilateral development banks. So it's the World Bank Group, Inter-American Development Bank, African Development Bank, European Bank for Reconstruction and Development, and the Asian Development Bank. And those institutions have formally agreed to recognize the debarments of the sister institute of the other institutions. And so each of the participating institutions almost automatically, there is an opt-out provision, but it is almost automatic, I would say, that the debarments of the other participating institutions will be recognized. So that is clear, again, because it's by agreement. But there are significant other number of institutions that recognize the debarments of the multilateral development banks. You know, some other international financing institutions, regional development banks, and others also recognize the debarments. So that, you know, so there again, that's another effect. But then there's even a broader knock-on effect, and that is where national governments, local governments may recognize the debarments of the multilateral development banks. So that can be very significant for companies, because some governments, again, formally will publicize that they recognize these debarments. Others, it's a bit more informal. But companies, you know, often will feel those effects. You know, they may want to bid on a local project, and they'll be told, "Oh gosh, we see you're on this, you know, World Bank Group, Inter-American Development Bank debarment list. What is that about? We may not proceed." And then there's another impact that companies may not always think about, and that's just due diligence in general. So, you know, companies looking to be for a business partner, you know, they're bidding to be a subcontractor, and the prime contractor may see that they're debarred. They may be looking for financing. The bank certainly will do their due diligence, and they will see that the entity is debarred. So again, the cross-debarment agreement is significant, but then these additional impacts really need to be considered, because that is where, you know, we hear very frequently from companies, that is really where they are feeling the hurt, I guess. You know, they may not do a lot of multilateral development bank work, but certainly, you know, if they're looking to get financing or looking to be a partner for someone else, that can significantly impact their opportunities.
Now, Roland, besides the cross-debarment provision that we mentioned, another recent addition to Brazilian law is the requirement that companies that win projects that are valued at for more than 20 million reais are required to have a compliance program. So compliance for those companies is now mandatory, and even for bids that are lower than 200 million reais, compliance can be a factor to untie. So if two companies come up with the same proposal, the one that has a better compliance program may win the bid. So those are examples of how compliance provisions are built into local procurement laws. Is this a trend? Are you seeing this elsewhere? Do you think that this will become more common as compliance continues to spread throughout the world?
Now, with regard to is that, you know, is it an international development that you will be obliged to have a compliance system? I think that's definitely a clear yes. That is an international trend. I think, you know, it started with the US many years ago with the FCPA. It took some years, but in Europe now we see a number of countries that have similar legislation which ask you to which factually require that you have a compliance system. So I think the most prominent example is the UK Bribery Act, but you had similar legislation in France, where you can have a criminal judge imposing a debarment on a company because you did something wrong. In Italy, there is a very strict compliance legislation. Basically, in Italy, it's based on the anti-mafia legislation that you have there, but it requires you by law to have a compliance system and a compliance officer, even in smaller businesses. In Germany this year, we see the implementation of a nationwide debarment system, where you will have for the first time a federal review of compliance systems by companies. And even at the European level, so the EU level, there is now a debarment system where you can have a European-wide review of the compliance programs. And perhaps a last part of the internationalization is the OECD, which was very early in this compliance area and basically adapted the FCPA to the international level. And the OECD, they have a number of very helpful guidelines on compliance and compliance programs. And there was just a report, I think it was issued in March of this year, on the corporate governance of state-owned enterprises in Brazil. So, and it's a 200-page report on the way in which compliance programs are implemented in Brazilian SOEs. So I think, if you see that even there is a strong impetus on having compliance programs implemented, I think that's all a clear sign that I think in a few years' time, if your company doesn't have a compliance system, you will be a very exceptional one, and probably will be much more difficult to have a running business.